by law to do this, or whether he was actually acting as a matter of abundant caution, as it states. I call the court's attention to Article 88 of the Constitution of Kenya, the provisions of the IBC, the Elections Act, as regards what a nomination is, and with particular attention to the definition of the word nomination. Amongst the other things, the Speaker of the National Assembly had no authority to approve a motion that was based on a law that was declared unconstitutional, because it cannot be a high offense. It cannot be a violation of anything. You cannot violate that which does not exist. That is amenable to review by this court. One of the other tests is whether the decision was made in excess of jurisdiction or power conferred under any written law. Now, the Senate, as senior counsel here said, worked with ungodly speed in impeaching the first petitioner before you here this afternoon. But apart from that, as regards the appointment of a replacement candidate, the Constitution has 74 days within which this decision could be made. 74. It was made at night, within less than 24 hours. So this kind of, there was no power to act with such ungodly haste when you are allowed 74 days to take your decision. Now, the speakers of both the National Assembly and the Senate, as my good friend Elisha Ongoya said here earlier, were beneficiaries and signatories of shareholder agreements which have been placed before you, which formed the basis of grounds 1, 5, and 6 of the impeachment motion. One of the fundamental rules of natural justice is that you cannot sit in judgment of your own cause. They were sitting in judgment of a cause in which they were not only beneficiaries. In the case of the National Assembly Speaker, who I have tremendous regard for, he was a signatory. As senior counsel here said this morning, the replacement, Honorable Kithure Kindiki, professor, a man I have a lot of regard for as well, was the witness of those agreements. The President of the Republic of Kenya signed and bound himself to those documents. And it's important to understand that these documents were not being done as a matter of abundant caution or as a matter of political games. The Political Parties Act requires a coalition agreement to be the foundational document for a coalition. So the Kenya Kwanza government is founded on the basis of these shareholder agreements. And when the deputy president, elected on the basis of those shareholder agreements, insists that those agreements must be complied with, he's called a tribalist and he's impeached. As Jesus would say, first take the log from your own eye. Impeach yourself as the government first for basing your government on a tribal agreement. Then get rid of your deputy president. Now, the National Assembly was scheduled to vote for the nominee to replace the petitioner before the Senate had voted. Again, senior counsel spoke to that, and I won't say much more. But what I will say is that last year, the High Court handed a decision, and I believe this was a 3 or 4 or 5 bench decision, and it's part of our list of authorities, in a case called Njiro and 11 others versus Kenya Kwanza Coalition and 18 others. It's part of our bundle of authorities. And this is what they said at paragraph 489 of their decision. We hold and find that the simultaneous holding of the position of Speaker with that of the leader of a political party and the leadership positions in the ruling political coalition, as is the case with the current National Assembly Speaker, Honorable Moses Wetangula, who is the leader of Ford Kenya and a holder of key position in Kenya Kwanza Coalition, reasonably evokes appearance of bias. And I say this because bias is one of the tests Section 7 of the Fair Administrative Action requires you to look at. And I continue. And undermines his neutrality role as the Speaker of the National Assembly and the independence of Parliament as the symbol of democracy, negatively impacting on our democratic standards as envisaged by the rule of law, principle under Article 10(2)(a) of the Constitution. And this is what they say. This dual role is unlawful and unconstitutional. I am aware that the National Assembly sought to stay that decision, and that attempt to stay was rejected by the Court of Appeal. There's a decision available on the Kenya Law website. And so, where you have a court decision stating that the referee, the man conducting this impeachment, the man issuing the decision, the man reviewing the motion, is biased, is a violation of the rules of natural justice. One of the decisions we have submitted before you, and my good friend Mr. Dudley is a bit more eloquent on pulling them out of his head quickly. The court has said that any decision emanating from a decision maker in violation of the rules of natural justice is not a decision. Now, when you look at, Articles 95 and 96 of the Constitution, the process of impeachment begins or is initiated in the National Assembly. Article 96 then uses some very interesting words and states that the role of the Senate is to consider and deliberate, not on the motion, on the resolution. Those are the exact words of Article 96. And so a resolution emanating from a process shepherded, led by an individual who has been found to be biased is no decision at all. Now, the person who, this is one of the other criteria that the court is to look at, whether the person who made the decision denied the person to whom the administrative action or decision relates a reasonable opportunity to state the person's case. It is important, while looking at this particular question, to examine, according to the first petitioner, where his problems began. I call the court's attention to paragraph 65 of his further amended petition, in which he states that his problems emanated from exercise of his freedom of expression, Article 33, following demonstrations that led to the unprecedented in Kenya's history occupation of parliament by the citizens of Kenya. That is paragraph 65 of his petition. And the reason citizens of Kenya, who called themselves Gen Z, occupied parliament was that they said they were not being heard. Their participation was not meaningful, and the only solution they could find was to occupy the August House. That is the beginning of this problem. And so, when Parliament embarks on a public participation process, it is incumbent on it to first advise itself of this history, that this man has been impeached because he made a statement in support of people who occupied Parliament. And so what do? And they concede public participation is necessary. My good friend Mr. Swanya will come and address us a bit more on this, but they give Kenyans 2 days to give public participation. When this court retires to look at the report, because what they did, they then collated, they issued forms. These forms had no serial number. These forms had no way of being verified whether these are Kenyans filling them or not. These were just forms that were distributed all over the place. But they then form a report. And when you look at the executive summary of this report, they say that they received 200,000 responses from the whole country. I did a bit of mathematics. 200,000 people as a function of the 14 million people who voted for the first petitioner and his president comes to 0.014 of the voters. Those are the people who participated. Now, I did a bit of maths in A level. When you round off 4, it becomes 0. When you round off 1, it becomes 0. So there was zero public participation, mathematically. It's that simple. 200,000 people out of 14 million is zero. A bit like the result I'm about to give you here on account of their compliance with the law. So you have 0%, and these are figures they themselves have given. In the executive summary, they list 10 problems they had with this public participation. They say there was very poor turnout. In one case, I think it was somewhere in KU, 168% people turned out to give their opinion. 68% spirits showed up to give their views in one particular case. And an order was actually issued against this process on that account. They then, in this form, list the allegations against the Deputy President. This is the National Assembly. But then don't give the people what the Deputy President's responses are. And this is not an idle issue I am raising here, because, as I stated, and under the Fair Administrative Action Act, Section 5, they must give the public the opportunity to consider all relevant material. All relevant material cannot include the plaint, but not the defense. That was a fundamental dereliction under Article 50 and under the Fair Administrative Action Act. They then say, based on these forms of theirs, that from the entire country, all 50 million of us, they received 8 written memorandum. 8. There are 41 petitioners before you this morning. There are more petitioners here than the number of memorandum they received. 8 of them. 1 per province. Kenya used to have 8 provinces. So again, on average, we got 1 memorandum per province of Kenya. That is what we call insufficient, inadequate, unreasonable, unlawful, unconstitutional. One of the other criteria the court is to look into is, and I think I should point out at this point here again, reasonable opportunity of being heard, which we'll find is one of the criteria. I won't say much about it. Senior counsel has dwelt at length about it. The Senate is informed that the Deputy President is unwell. They even ask senior counsel, it's part of the Hansard, to convey quick recovery to him. It's actually there. They tell him, go tell him to recover quickly. Pray for him. They then say, but while you are praying for him, we will proceed here to hang him as you are praying for him. This is what they did. Now, how are we ever going to face Kenyans? By telling them this is what a fair hearing in Kenya looks like. As we are praying for you, we are slaughtering you here. We are praying for you with one hand, slaughtering you with the left. How are we ever going to face Kenyans and tell them that is the kind of justice we practice in this country? How are we ever going to tell them that is what Article 50 as regards a fair hearing means? One of the other criteria is that did the decision maker omit or fail to take into account a critical issue, or did they omit a condition prescribing the power they are to follow? My good friend Mr. Dudley here again has talked about the Senate proceeding to vote without appointing a special committee. The court has enough material on that, but the courts, and I say so with tremendous respect, will also have time to look at what the Supreme Court said as regards this committee. It said, we recommend the committee route as opposed to this lynching. The words lynching came from them there. Mob justice, goon justice. They said, do a committee. You'll have time to look at that. I've said they did not conduct a constitutionally compliant public participation exercise. And as I said, it's required not only by the law, Articles 10, Article 118, Section 5 of the Fair Administrative Action Act. But again, my lords and your ladyship will have time to look at the BAT case, again the Supreme Court case, that gave the 8 or 10 criteria that are to be looked into in examining whether public participation was properly carried out or not. Among the other criteria that the court is to look into, again from the same Section 7, is whether the administrator failed to take into account relevant considerations and took its action or made the decision in bad faith. Did they consider everything they ought to have? I have a long list of things here, and I won't spend any narration on them. One, they did not take into account the Wambora Court of Appeal principles on the threshold test for impeachment. That is where the threshold test was made. They did not take into account the Sonko Supreme Court case principles on the need for a special committee. They did not take into account the BAT Supreme Court case principles on public participation. They did not take into account the Onyango Olo Court of Appeal case principles on fair hearing, and in particular, what is adequate time given the circumstances. At this point, I should point out, when the Supreme Court is determining whether to annul or uphold the president's election, it normally has 14 days. It normally gives a summary judgment and then reserves reasons for many months later, again because there just isn't sufficient time. And so, why the National Assembly and the Supreme Court in 2022, in its judgment, actually said we ought to amend the Constitution to provide for more time, you know? Now, why the National Assembly, which has been asked this, and in fact, in 2022, the Supreme Court said this judgment should be served on the National Assembly for them to remedy this question. Both National Assembly and Senate did not take into account Article 50 on the fair hearing requirements. They did not take into account Article 94(4) of the Constitution, which requires them to protect the Constitution and promote the democratic governance of the Republic. I've already cited Section 5 of the Fair Administrative Action Act and other provisions of that act. The resolution by the National Assembly adopting these allegations, which concerned spurious, frivolous, vexatious matters about the first petitioner's family matters, which had been dealt with by a succession court, which was the subject of rulings by the family division, were thrown in just for the heck of it to harass the man, and were designed to violate his rights under Article 31C, which protects every citizen from having information relating to their family or private affairs unnecessarily required or revealed. And in the fullness of time, you will find the Senate actually refused to uphold this ground. The ground had been put there purely to embarrass him, to embarrass his family, to embarrass his supporters, to harass the man. That cannot be a proper motive. That is an improper motive by this party. They failed to consider that the DP, and again, this is the Alai case. My good friend, Mr. Dudley, referred it to the Alai case. In the Alai case, the court said, and there'll be another case I'll be reading out here for you shortly, called Ferdinand Waitito, that you are free to express your opinion. And so, as I said, the first petitioner begins at paragraph 65 by saying all his problems are because he spoke about the manner in which his government had mismanaged the demonstrations by these young people called the Gen Z. Now, we are about to compensate them for shooting and killing them. Now, this will be the first judicial decision that will provide guidance on the interplay. This is an important one because it keeps being repeated, and my learned friends here have paragraphs upon it in their submissions. The interplay between hate speech and incitement, which are stated to be offenses under sections 13 and 62 of the National Cohesion Act, vis-a-vis the freedom of expression under Article 33, the political rights at Article 38(3)(c), and the rights of all citizens, including political leaders, to advocate for and protect, express ethnic rights identified in the Constitution. I say ethnic rights with that reason. The first petitioner is accused of stirring hatred, potentially inciting people, because he used the word Mount Kenya. The little geography I learned, Mount Kenya is a rock in the middle of Kenya. It is not a tribe. It's a stone in the middle of Kenya from which we got our name as a republic. Even if you are to count the counties that surround it, they constitute people from every corner of Kenya. They don't have one tribe. He didn't use a tribe. He said Mount Kenya. Mount Kenya is a rock. He can talk about a rock. Number two, even if he was talking about ethnicity, Articles 21 27, 63, 90, 91, 100, 130, 232, 241, 246, 250, and a myriad of statutory provisions that I could bring here all talk about ethnicity as a constitutional principle worth defending, worth being held to account for, worth advocating. All of those mention the word. In fact, I found that the word ethnicity appears more times than the word economy. Economy appears twice. Ethnicity 11 times. So, how can you be accused of speaking of an issue the Constitution spent 11 articles talking about? But even more important, in 2016, the late Justice Louis Onguto had occasion to consider a case I have circulated to my colleagues this morning after I got their submissions, and I think I have given the court, my good friend Mr. Njomo had the court's copies. But this is the case of Ferdinand Dongo Waitito, also known as Babayao, and 4 others, versus the Attorney General. It's reported. This is what Judge such as those about to be made by the respondents, and this is what it says. The Constitution allows every person to picket, demonstrate, assemble, and present petitions. Picketing and demonstrations themselves invite the right to express opinion. The opinions may be controversial. The opinions may appear contrary to the law. Appear contrary to the law. This is just Jayongo saying this. The opinions may not find favor with others. Yet, the Constitution anticipates and expects that such unpopular opinions, howsoever expressed, be respected. Now, not all of us can speak as good English as my good friend Dudley or my good friend Professor Ujiambo here. But you're free to express yourself as you will. If you read a document that talked about shareholders, that is what you say when you go to the public. Why would you be vilified and impeached from ever holding public office for reading a document that founded a government? On what basis? He then says, even if they invite disagreements and counter demonstrations, this is the first time, I think it's good, Kenyans would know, counter demonstrations are allowed, not just demonstrations, even counter. The Constitution thus far declines to stifle even the most unpopular view unless it is intended to incite persons to violence, propagate hate speech, is propaganda for war, or advocates hatred through ethnic incitement. When you retire to look at the provisions of the National Cohesion Act, sections 13 and 62, that are the basis of these frivolous grounds, they say the critical function is what my professor, Gideon Muigai of criminal law, used to tell us was called the mens rea, the intention. Did you have the intention to cause hatred and incitement? You cannot have had the intention when the document you are reading is the basis for the government that was formed. You cannot incite people with the government. You reward them with a thing nowadays called power and economic empowerment. You do not incite them. You can't cause hatred by talking about a government that was elected by people on the basis of a document. And so the DP's public references as regards these shareholders cannot be tantamount to hate speech. They cannot. This is public speaking, as I've just stated. And I should state here, the case of Ferdinand Dongo Waitito and the 4 others, among the 4 others are the current leader of majority in the National Assembly. So he knows this. When they were considering these grounds, he was aware of this decision because he was one of the petitioners. And they were told, no, you can't stop people from talking. Now, but then, they then went to the Supreme Court, the Court of Appeal, sorry. They tried to overturn this decision, and the Court of Appeal rejected that attempt. So this decision, I'm reading Ferdinand Waitito, has been upheld as well by the Court of Appeal. There are many instances where one would be said to have caused the hate speech or incited people or have said things that weren't popular. The first petitioner is accused of having spoken against the National Intelligence Service. When you retire to review the material before you, this is the Senate Hansard, And this is ground number 9, which we'll find at page 64. There is an interesting exchange where my good friend Ekomas Mutuse is being interviewed, is being cross-examined on the question of the NIS. And he's directed to a case where the current president, who, while deputy president, also very harshly criticized the NIS. So criticizing the NIS has not started now. In fact, the current first petitioner, who was the deputy president, should be accused of being a good student of his boss, the former deputy president, who's currently the president, because he too also criticized the NIS. So, and the NIS, as with any other state organ, can and should be criticized. No one is beyond criticism so long as it is well-founded, as turned out in this case. It is made politely. It is stated in good English, relatively good English. Our client spoke some fairly good English. He's a literature graduate. He said nice things. He said them nicely. Now, they offended the heart. But you know, no one is beyond criticism. One of the other things, I think, and we've stated this in our petition and submission, again, on the question of bias, the National Assembly Deputy Speaker, the 8th respondent, is on record as saying her instructions to execute the impeachment came from a building in Milimani called State House. And one of the things the court is invited to look at is whether the person exercising this decision acted on the direction of a person or a body not authorized or empowered to give such directions. Now, one of the other issues that this court is asked to look into is whether the administrative action is rationally connected to the information before the administration. Again, as I have said, it cannot have been rationally connected to this decision when among the grounds was a law that did not exist, was issues pending before the succession court, was the exercise of freedom of expression under Article 33. I will not repeat the question about the issue, but it's one of the other issues, again, you'll be able to look at. The question of these shareholder agreements, I need not say any more about that. But is the decision unreasonable? The ungodly rush to execute a premeditated decision is unreasonable. A one-day notice to the public to conduct public participation regarding a matter that even this court has said is of great public importance is unreasonable. Conducting public participation in which the public only has access to the impeachment motion, a summary of it, by the way. The evidence was not given to the public. They were just told he has violated Article this, Section this, and Section that. Most lawyers could not tell you, with most, leave alone the public, other than my good friend Mr. Umtata. No public member can read these sections out of their head. And yet this is what they were given on this document and told, should we impeach this man or not? Passing a resolution based on public participation, as I said, that had 0% of voters who cast the vote in 2022, is unreasonable. One of the other criteria is whether the administrative action or decision is not proportionate to the interests or rights affected, and whether the impugned action or decision violated the legitimate expectations of not only the deputy president, but the nation at large. Now, the case I cited earlier, which is the 2025 IBC versus AG case, states the following words. Kenya's history is one of executive overreach and institutional compromise. This is what the Supreme Court said last year. And for the avoidance of doubt, Section 12 of the Fair Administrative Action Act states that the act is in addition to and not in derogation of the general principles of common law and of natural justice. Now, as I said, the National Assembly and the Senate violated all known canons of fair hearing and constitutional procedure. Amongst the most harmful things they did was to destroy almost the principle known as the principle of legitimacy. The principle of legitimacy has 3 pillars. Pillar number 1, people must have voices and their voices must count. That's the first pillar of the principle of legitimacy. The second one is that public affairs and the law must be conducted with fairness and justice. That too was violated. And thirdly, that laws and rules must be consistent and applied evenly and predictably. I repeat, the current deputy president is the witness of these shareholder agreements that led to the impeachment of the deputy president seated here. The president, the Speaker of the National Assembly, the Speaker of the Senate, all are members of parties that signed and are beneficiaries of this agreement. How can we say the law is being applied equally, fairly, and evenly, even in the limited space of the political players, when one group is treated one way and one individual is treated another way? I want to rest this area of my submissions, and perhaps maybe you should allow me to just read for you, as I found my notes on the provisions of the Elections Act and the IBC Act that deal with the question of nominating a deputy president. These are Articles 82(1)(b), Article 88(4), the definition of the word nomination at Section 2 of the Elections Act, Section 22 of the Elections Act, and Section 4D of the IEBC Act. I want to close with the following paragraph taken from the decision of the IEBC versus Attorney General 2025 case. This was a case concerning the delimitation of boundaries, and the Supreme Court of Kenya said as follows. And this is the penultimate paragraph of their judgment. However, before we conclude, we must address a matter that has troubled us. And it is my very, very tremendously humble and respectful request to this court to also be equally troubled by the things that the National Assembly and the Senate did in this matter. The history of Kenya's electoral process, from the findings of the Kriegler Commission after the 2007-2008 post-election crisis, to the litigation around elections culminating in the 2022 presidential election, reveals a consistent theme, one of a deep-seated trust deficit. I beseech this court, do not countenance any further trust deficit based on the things the National Assembly and the Senate did. Trust deficit between Kenyans, the IEBC, and the electoral process. This deficit did not occur by accident. It occurred because of actions like the ones by the National Assembly and the Senate. Rather, it is the product of decades of politicization of the electoral process, relentless attacks on the Commission's independence, and a failure to implement electoral reforms in a good time and in good faith. Leaders exercising delegated authority, such as the National Assembly and the Senate, on behalf of the people under the Constitution, rather than fueling this mistrust for short-term political gain. It appeared last year, 2024, when the impeachment was going on. It seemed that there was a deadline by 20th October. And when I slept, I woke up with a eureka moment. The idea was to have a new deputy president at the holiday. You know, it gripped me. I hadn't seen it before, you know. And so undermining the very institutions they are duty-bound to protect should channel their power and influence toward addressing structural weaknesses, enhancing accountability, and reinforcing public confidence in the impartiality and competence of the IBC. In this case, I say of decisions by the two bodies before you. Ultimately, the legitimacy, which is why I spent some time talking about the doctrine of legitimacy, and this is what they say. Ultimately, the legitimacy of Kenya's democratic order depends not only on credible institutions, but equally on the fidelity of political actors to the spirit of the Constitution and the sovereignty of the people, which was in question during this impeachment. Unless your ladyship and my lords have any questions for me, I want to thank you for the the privilege of your time and attention. I'll rest at that point. I hand over to my senior, Mr. Swanya.
Thank you. I would like to make this comment that repeated issues are coming up in your submissions, and I want us to believe that we have had most of those issues. If you find that you are bound to repeat what has been said, we want to assure you that it is not necessary.
Thank you. My name is Swanya. I'll address the court on notices. But before I do so, let me cite the Supreme Court, a case on PAT, which says public participation is a constitutional requirement under Article 10 and 118 of the 2010 Constitution. The Supreme Court in a PAT case held that public participation and consultation is a living principle that went into the constitutional tenet of the sovereign of the people. Under Article 10, Sub-Article 1 and 2, as a constitutional principle, public participation binds and it is applied to all aspects of governance. Your Honors, and Lady, I want just to get down to some specifics on public participation. It is designed to ensure accountability, requiring public engagement, rather than just parliamentary approval. In the context of impeachment, it is a remedy of the last resort. This, I think, was mentioned by Senior Counsel Paul Mute. Therefore, the public participation exercise must meet the following standards, and this is what I wanted to get down to the specifics. One, must be purposeful and meaningful. Must be real and not illusory formality. It is not cosmetically done for Public Relations Act. Should not be undertaken as a matter of just to fulfill a constitutional requirement. The public participation exercise outcome must have quantitative and qualitative components. It is accompanied by reasonable notices and reasonable opportunity. Further, Your Honor, the court tried to highlight what is the components of meaningful and purposeful public participation. It must have clarity of the subject matter of the public, for the public to understand. The structure and process as a media of communication of the participation participation that are clear and simple to understand and follow. This particularly is the instruments that are used to collect data or to be given to the participants on public participation. They got to be simple, clear, and easy to follow. There must be opportunity of balanced influences from the public in general and commitment to the process. It must be inclusive of effective representation, integrity and transparency of the process, and capacity to engage on the public, including that the public had to be first be sensitized on the subject matter. These are the details that our guidelines the Supreme Court gave on the PAT case. So now let me just get straight to the notices. Before I get to the details of it, let me define what a notice is and a reasonable notice. A notice is a formal information to parties attached or necessary to a judicial process, informing them about the issues they need to know and given an opportunity to respond to them. The courts always will rely on the parties to properly serve notices to the affected parties. A proper notice is regarded to be proper and adequate when it has the following elements. Number one, it must be in writing and indicate the date issued. It must be clear and precise, or state the clear and precise object of the notice. Provide specific venue and duration if necessary. Provide adequate timelines and periods as may be stated in a statute or an agreement. It must refer to a statutory or an agreement or resolutions, and of course must be served. In the case of Battle versus Globe and Mails Limited, 1960, this a Canadian case, the Supreme Court, Ontario, clarified what is agreed, clarified on the reasonable notice, that where there is no agreed timeline in a notice, a reasonable notice kicks in. It is a common law concept that refers to fair amount of time that must be provided for the parties to respond to a matter that concerns them before a decision is arrived. The Lord, I brought this up because we do not have a codified law that guides the impeachment process, which has guidelines on the notices and durations, or steps to be taken for an impeachment. And what we have only is what the Supreme Court, in the case of PAT, has given as guidelines. And so one of it is reasonable notice is necessary. And that's why I've referred this case where there's no notice, then automatically a reasonable notice kicks in, and it talks about the timelines. Now let me state also in the case of Robert and Gakuru versus Governor Kiambu County, the court has been clear that arid or poorly publicized processes amount to illusory participation, being a formality incapable of influencing the decision. Therefore, reasonable notice to the 290 constituencies must be understood as notice that is sufficiently served early, widely disseminated, and accompanied by accessible information for realistically enable the citizens to engage. Anything less, particularly involving inordinately compressed timeline, undermines the Constitution standard by denying the public a genuine opportunity to study the issues and be able to formulate a position and present meaningful representation capable of shaping the final decision as in the present case. Your Honors, I now submit on the National Assembly's failure to meet the standard of reasonableness and meaningful engagement. The National Assembly, in their own report, reveals a process that prioritized speed over substance, failing the reasonableness test as follows. The notice ran for only 2 days. That is on 2nd and 3rd October 2024 for the public participation exercise, which was to be held on 4th of October 2024 at a purported initially a designated single venue at the county level. Additionally, the National Assembly report on 3rd and 4th October 2024 stated they had 40,000 copies of the notice of the special motion were circulated as newspaper pullouts. This begs the question whether the 40,000 copies were adequate for meaningful national public participation, and whether the 2 days were adequate for circulation of the same nationwide. My lords, we submit that the timeline were fatal to the meaningful engagement, because the entire national exercise was condensed into a 4-day window inclusive of the 2 days notice advertisements. This time frame is grossly insufficient for the public to digest a 100-page motion containing 11 complex grounds, legal grounds, including allegations of corruption and gross economic crimes. Your Honor, it's important to note that the first notice had a single venue per county. Your Honor, you can imagine an headquarter of a county, assuming that's where the exercise was taking place. The people who are at the ends of the county, how would they access to reach the venue and participate in the public participation exercise? This is contrary to actually what the Court of Appeal, the Supreme Court, rather, guidelines had provided for. The other point, Your Honor, according to the report, the nationwide public participation exercise at the constituency level gave 1 day notice on 4th of October 2024, the same date as the court ruling. Let me clarify here that the participation exercise was supposed to be on 4th of October 2024 for 1 day. But the ruling of Justice Moho, your brother, extended the participation for another 1 more day. Now, that advertisement or publication also came in the same day when these exercises were supposed to finish. Now, what would happen that to the common mwananchi? Of course, confusion. Similarly, the orders which were given said that now the exercise should move from the county to the constituencies. The Honor, what we noticed here is that in the constituencies, just talked about constituencies, never gave a specific place, address, where this exercise is supposed to take place. It's our submission that such an important exercise to remove the deputy president from office, who was elected by the majority of Kenyan in each gazetted polling station in the country, required a similar methodology and the participation to remove him from office. And certainly, the purported NGCDF officers advertised without prescribed venue address did not meet Justice Mwongo's court order to provide venues close to the people. In any case, the only venue close to the people is polling stations. The Honor, here, as I said earlier, even with the orders, needed to have the exercise done at the constituency level. And the assumption here is that each constituency has these officers. But then what's the distance between where those officers are? They were not prescribed. For somebody who's at the end of the corner of that constituency. By using highly legalistic language in the notices of public participation and in the circulated public view template, the assembly created a barrier to entry for the average mwananchi, reducing a constitutional right to a binary of support or oppose vote. The report indicates that primary information was posted on the national television, broadcast, KBC, print media, the parliamentary website, and social media, which was technologically biased and excluded vulnerable groups. In the BPI case, the court stated that relying heavily on technology ignores the reality that only a small fraction of Kenyan as reliable internet access, and that technology has not been dispersed equitably to all Kenyans. Similarly, despite the Persons with Disability Act of 2025 requiring free sign language and braille in public forums, the Gachagua impeachment exercise failed to provide even the most basic reasonable accommodation for these 5% of the population with special needs regarding the exercise, which was unconstitutional as per Article 54. The report does not demonstrate that the public was provided with copies of the special motion, including the grounds in English, Kiswahili, prayer, and other communication channels and technology accessible to persons with disability, such as the Kenya Sign Language. In Turkana, as an example, as well as other marginalized regions where the report shows zero response via hand delivery and email, the report does not demonstrate whether it provided any mobile registration units or outreach as required by the PPI case to ensure nomadic communities were also involved. The notice, as I think has been mentioned again, presents a one-sided script. It presents the public with the grounds for impeachment without the first petitioner's response. This was not a search for truth. It was an exercise in prejudice. By suppressing the petitioner's side of the story, the state violated its rights to fair hearing and public's right to make an informed decision under Article 47 and 50 respectively. And this is found in our submissions, page 48 and paragraph 107. One submit that since the reasonableness of the notice is to be determined on case-by-case basis, the adequacy of notice in the present impeachment process can be tested against the scale of electoral mandate it seeks to overturn. This is found also in the submissions, page 47 and paragraph 104. In 2022 Kenyan general election, the presidential mandate was exercised by approximately 14.3 million voters out of about 22.1 million registered voters nationwide, reflecting a wide democratic participation. Out of those who cast valid votes, roughly 7.1 million supported the ticket of William Ruto and Rigathi Gachagua, thereby conferring upon them the constitutional mandate to govern. This mandate was granted by voters decentralized across the 290 constituencies and dispersed across at least 24 counties in accordance with the constitutional requirements. That is also in our submission, page 4 and paragraph 2. Therefore, by contrast, a constitutionality compliant impeachment process ought to demonstrate that the public participation notices reached a substantial and representative proportion of that electorate. In the present case, the notice issued reached only a negligible fraction of the electorate, attributed to short times, limited publication channels, and accessibility to forums, which processes clearly falls short of the constitutional standards. And of course, my learned friend Tom Macharia has mentioned that this is evidenced by the alleged 200,000 plus viewers in the National Assembly report, which constitutes about 0.14% of the vote that mandated their win. Your Honor, statistically, of course, it sums up to a 0%. If it was a medical test, it will show negative results. There were only 11 memoranda that were presented to Parliament. Your Honor, and again, this I think has been said, I don't repeat it. This begs the question whether the National Assembly is suggesting that the sovereign will of 22.1 million registered voters in the nation is carried in the presence of the 200 plus individuals who allegedly participated in the exercise. Your Honor, as you retire, you will find that the National Assembly's failure to issue reasonable notices contributed to the dismal performances in the public participation exercise, which cannot be taken to proportionately hold the views of the majority who voted the President and Deputy President into office. I also dare to say that the mode of the instruments that were used to collect information, the template instruments used in the public participation exercise lacked clarity, thus ambiguous, contrary to the Supreme Court guidelines. The viewers template instruments to collect data from the public participation exercise failed verification and identifiability test. And of course, we've mentioned that initially, which I think is a point note, they were the first templates that did not have provision for identification. Then later, they were replaced. But we don't know the forms that were already in the public. What happened with them? Did they collect data? Is that data part of what was collected and reviewed? That information we don't know. Parliament equally did not state clearly how they were verifying the information they got from the public. Finally, let me just finish now. I wish, just to draw to your attention, this was your ruling here in this court, in the same case of Gachagua. Gachagua and 40 others versus the Speaker of National Assembly and 15 others. 224 KEH 13473. This is what you stated. The impeachment case exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue. One that has significant implication for the doctrine of separation of power. Your Honors, the eyes of the nation are indeed upon this court. We echo your sentiments in paragraph 101, which reminds us that the people of Kenya fought for a transition away from marginalized judiciary. They envisioned a new order where government excesses are checked and where no harm of government operated beyond scrutiny. If the standard of public participation is allowed to fall as low as it did in this case, characterized by unverified templates, digital exclusion, and binary trap, then the Constitution promise of the will of the people becomes a dead letter. Thank you, Your Honors, for the opportunity to address you.
Thank you.
Good afternoon, my lords and my lady. I rise to highlight issue for determination E.
Your name, please.
My name is Echesa Willis. My lords and my lady, I do rise to address and highlight submissions with regard to the issue for determination number E, that is at page 11 of the issues for determination, as have been crystallized by the first petitioner. My lords and my lady, the substance of issue number E is to be found at page 51 of the first petitioner's submissions. And my lords, taking cue from the presiding judge's direction, I will not repeat what my learned colleague, Mr. Tom Macharia, has addressed the court with respect to Article 47 of the Constitution, as well as Article 50, sub-Article 1, with regard to the right to fair hearing as well as fair administrative action. My Lord, I will, for purposes of guiding the court in appreciation of this issue for determination, I will draw the court's attention to the further amended petition, specifically averments contained at paragraph 97, as well as paragraph 106. I know that is the foundational essence of the issue for determination that I shall be highlighting. My Lord, further to that, I do redirect the court's attention to the affidavit in support of the petition sworn by His Excellency Rigathi Gachagua. My Lord, this is sworn on the 18th of October 2024. And my lords and my ladies, specific to the issue that I'm highlighting on, issue number E, my lords, I do direct the court's attention to the deposition made at paragraph 8H, that is at, it's not paginated. The next factual preposition, my lord, is the deposition made at paragraph 22. And lastly, I shall make reference to the supplementary affidavit of His Excellency Gachagua, sworn on the 27th of October 2024, specifically at paragraph 6. My lords and my lady, against the backdrop of what my learned colleagues that have made submissions ahead on the provisions of Article 47 as well as Article 50 sub-Article 1 that embody the requirement of fairness in decision-making before decision-making bodies, as has been submitted, my lord, the role of the Senate in this particular proceeding leading to the impugned impeachment, it has been submitted ably by my learned colleague, Mr. Macharia, that this was a quasi-judicial process. My lord, submissions have been made with reference to, and in this particular, at this particular juncture, I do refer to the exhibit RG1, that is, my lords, the exhibit to the supporting affidavit that annexes exhibit number 1 that starts at page 566 through to 566 through to 583. My learned colleagues did indicate that there were pre-coalition agreements, and my lord, I would urge this court to take note of the specific provisions in these coalition agreements, specifically at page 588, which is specific with regard to the reservation of the position of the Speaker of the Senate. My lord, I refer to, this is the agreement between the Kenya Kwanza Alliance Coalition and the Pamoja Africa Alliance Party. Next, my lord, is page 567 that exhibits the coalition agreement between the United Democratic Alliance and the Amani National Congress Party and Ford Kenya Party. I will redirect the court's attentions to page 578. This is at paragraph, this is at article 21, subparagraph L and N. My lords and my lady, what those annexures, the purpose of that, of those annexures is to amplify the fact that the speakers of both the National Assembly as well as the Senate were direct beneficiaries to the pre-coalition agreements that were in place, and that which had been submitted by the first petitioner first before the National Assembly on the 8th of October 2024 in response and in his defense with respect to ground 1 that raised the charge on the so-called shareholding issue. My lords and my lady, the point to underscore in regard to those coalition agreements is that as early as the 8th of October 2024, when the first petitioner tendered his defense to the grounds that were purportedly moved by the National Assembly, it was clear that part of the evidence that the first petitioner was to present implicated or showed the involvement and the interest of the Speaker of the National Assembly. However, my lords and my lady, the Speaker of the National Assembly did not deem it fit to recuse himself, noting that the issue of his interest would play out in the defense of His Excellency Rigathi Gachagua. Further to this, when the motion was or reasonably believed that it was seen by the then Speaker of the National Assembly, the Speaker of the Senate, that the coalition agreement that begot him his speakership was also in question, as it had been brought up by the first petitioner in his defense of ground 1 that had been then passed by the National Assembly. In summing up, my lords and my lady, impartiality is essential for decision making, and as my learned colleagues have indicated, the process demonstrated what my senior counsel, Mr. Ongoya, has referred to as malicious compliance, breakneck speed with regard to the moving of the motion, as well as the directions, as well as interpretation that was given to various provisions of the Constitution by both the Speaker of the National Assembly and that of the Senate. In summing up, my lord, the petitioner has, in his bundle of digest and bundle of authorities, made reference to the decision of Njiru and 11 others versus Kenya Kwanza Coalition and 18 others, which my learned colleague, Mr. Macharia, made reference to. I do urge your lordships and your ladyship, when this court retires to deliberate on the ruling, on the judgment, to be guided by the 3 judges in holding number 20 and 21 of that decision. I do submit that those 2 holdings are on all fours on the submission in relation to Article E before this court. So the issue for determination at E before the court. And in closing, my lord, with reference to the issue for determination whether or not the speakers of both the National Assembly and that of the Senate were neutral, I do invite this court to do what the court recommended in the decision of Philip K. Tunoi and another versus the Judicial Service Commission, and another, it's a 2016 decision, where the court held that in determining the existence or otherwise of bias, the test to be applied is that of a fair-minded and informed observer who will adopt a balanced approach and will neither be complacent nor be unduly sensitive or suspicious in determining whether or not there is a real possibility of bias. I do invite this court to apply that test. And my lords and your ladyship, based on what has been presented by the petitioner, we do submit and urge the court to find issue number E in the affirmative. I'm much obliged.
Thank you.
May it please your lordships and your ladyship, my name is Faith Waigwa for the first petitioner. My lord, I shall be addressing you on issue G. Issue G is the second last issue framed by the first petitioner and speaks to the invalidity of National Assembly Standing Order number 64. To start off, my lord, at paragraph 147 of the first petitioner's submissions, dated 7th October 2025, we did highlight the issue as National Assembly Order number 46 as opposed to 64. So we wish to correct that now. The body of the paragraph speaks to the correct provision, which is 64. It's just the heading that there was a spelling mistake. My lord, the question we pose on this issue is, can an internal procedure of Parliament, internal procedure rule of Parliament, namely the National Assembly Standing Order 64, constitutionally compress an impeachment process of the magnitude where a deputy president is being removed into timelines so short that they effectively extinguish the constitutional duty to facilitate meaningful public participation? My learned colleagues and seniors have ably submitted on the issue of public participation, but I'll try as much as possible not to repeat, though, my lords, you'll allow me to demonstrate why this particular provision of the standing order goes against the constitution provisions of public participation. And to that extent, we will be answering our question in the negative. And towards the end, we will invite you, my lords and my lady, to find that that standing order 64, 2 in specific, and to the extent relevant, 64(6) are unconstitutional, null and void, to the extent that they impose timelines whose purpose and effect is to undermine Article 10 of the national values, Article 118 on participation by the public, Article 1 on sovereignty, Article 2 and Article 124 of the Constitution. My lord, this is not an attack on parliamentary autonomy. It is a defense of constitutional supremacy, and we proceed to demonstrate as follows. A procedural rule that makes meaningful public participation impossible is itself unconstitutional, however neatly drafted. The vice in Standing Order 64 is not merely that it provides timelines. The problem is that those timelines are constitutionally disabling. And I will demonstrate what Standing Order 64 provides. It requires, one, the National Assembly's Speaker to dispose of an impeachment motion within 3 days of its notification. Thereafter, it provides the disposal of the impeachment motion by the National Assembly within a period of only 7 days. We have 339 members of the National Assembly who are supposed to dispose of the impeachment motion within 7 days. And lastly, it provides for transmission of the resolution of the National Assembly once they've passed the motion to the Senate within 2 days. The real vice falls under under Standing Order 64-2, where the National Assembly has only 7 days within which to dispose of the impeachment motion. This standing order compresses a matter involving reversal of several sovereign electoral choice into 12 days, thereby making meaningful public participation illusory. And where participation becomes illusory, Articles 10 on participation of the people being a national value and principle of governance is affected. And Article 118 on public access and participation is also affected. Article 2, my Lord, of the Constitution is supreme. Anything inconsistent with it is void. The standing orders themselves derive their authority under Article 124 of the Constitution, and therefore, they do not sit above the Constitution and cannot cut down constitutional obligations. The Supreme Court in Mate and another versus Wambora and another, 2017, the court held as follows. Courts have jurisdiction to interrogate even parliamentary standing orders for constitutional compliance. So this principle, my lords and my lady, answers any argument by the respondents of non-justiciability. This honorable court is being invited to supervise parliamentary politics. It is being invited to perform its constitutional duty of reviewing constitutionality. My lords and my lady, constitutionality is judged not only by text, but by purpose and effect. So we look at what is the purpose of Standing Order number 64-2. Its purpose is to force expedited disposal of impeachment motions. But what is its effect? In reverse, to restrict Parliament ability to facilitate meaningful public participation in the impeachment proceedings. With this, Standing Order number 64-2 has a purpose and effect that undermines constitutional rights and national values and principles of governance, and therefore should be found to be invalid. The petitioner specifically pleads this at paragraph 98 of its further amended petition. And that is the vice before this honorable court. My lords and my lady, impeachment is not ordinary parliament business, and that has been admitted by the respondents when they say impeachment is not necessarily a legislative process. It seeks removal of a directly elected constitutional office holder, and in practical terms, revisits the sovereign will expressed at the ballot. It is that serious. Such a process demands heightened constitutional safeguards, not reduced ones, like we have seen in Standing Order number 64. Yet Standing Order 64 does exactly the opposite, my lord. That inversion should then be found to be unconstitutional. My lord, I won't repeat what has been submitted before you on public participation. However, you've heard clearly that public participation conducted on the 4th and 5th of October 2024 did not meet the threshold of the principles laid out in the BAT case. This is the British American Tobacco Kenya PLC versus Cabinet Secretary of the Ministry of Health. And allow me to just point out what violations were made. And had we had more time, had the National Assembly provided for more time in its standing orders, perhaps they would have averted these particular violations. One, Mr. Swanya indicated of the no reasonable notice was issued. A notice of extension of public participation was issued on the 5th of October 2024, which was the last day and D-Day for public participation. There was no reasonable notice whatsoever. There was no informed participation. The people of Kenya were provided with information that was minus the defense by the first petitioner, where they had one-sided story for them to consider whether to impeach or not to impeach the second deputy president. There was no balanced influence. We've heard clearly that at Bomas of Kenya, participants were actually told that the forum was for invited members of the Orange Democratic Movement. That's ODM party. Members of parliament swayed participants during this engagement. We've heard that. Therefore, the process was partisan and violates the requirement of balanced influence. We've also heard of the no integrity or transparency because forms were unverified and cannot still be verified to date. No serial numbers on those forms that were used for public participation. No methodology was disclosed. And statistical anomalies such as 162.78% support in Keyo South was reported. Clearly, we will all agree that this speaks to constitutional fraud. Again, my lord, I reiterate, if the National Assembly had more than the 7 days required to dispose of this notice, this motion, impeachment motion, then perhaps these violations would have been averted. The respondents may argue timelines alone do not invalidate a process. However, our response would be not every short timeline is unconstitutional. So we might agree. But a timeline becomes unconstitutional where it makes constitutional compliance impossible. And that is the case with Standing Order number 64. Why do we say the timelines there are unreasonable? First, it allows no genuine civic education before participation because the public participation was conducted by National Assembly. Second, it allows no adequate dissemination of relevant information across 290 counties. Third, it allows no serious compilation analysis and debate on public views and violates procedural fairness. The fact that the defense of the first petitioner was never disseminated to the public to make an informed decision, that process was unfair. My Lord, allow me to compare these timelines with those of the presidential election petition. We all know and understand that a presidential election petition is filed by a person who has arguably lost a presidential election. This petition is supposed to be heard and determined within 14 days by a 7-judge bench. In contrast, when removing the same president who's been confirmed perhaps in the presidential petition, the National Assembly allocates itself only 7 days to remove a president or a deputy president who was validly elected using universal suffrage, and the people sitting to remove the president or the deputy president are 349 members of the National Assembly against only 7 judges at the Supreme Court when hearing and determining an election petition. My lords, there is a problem. That removal has to be extremely fast, but confirming can have more time. Confirming a president can have more time, but the removal of such a president or deputy president must be extremely fast. My lords and my lady, I'll draw some comparatives from parliamentary systems of government, which my learned colleague, Ochiel Dudley, was able to bring to your attention. We did the research with him. In Nigeria, the timelines are 4 to 5 months. 4 to 5 months for the entire process. In Kenya, the process is around 2 weeks to 4 weeks maximum. In South Korea, Constitutional Court is given up to 180 days to render its determination. In the US, my lords and my lady, we will be surprised that there are no rigid timetable. But historically, what has been happening is around 2 months or more. And the reason is that the flexibility exists because of the gravity of such matters that demand deliberation. So you will find from the countries we've drawn your attention to is that they are more of an investigative process as opposed to a mob justice process that took place in our country at the National Assembly. Why are we comparing this? This comparative material is not cited to import foreign constitutions. It is cited to illuminate a constitutional principle. Basically, Kenya is an outlier when it comes to timelines for removal of its president or its deputy president. Where removal overturns a popular mandate, constitutional democracies favor deliberation, investigation, and participatory legitimacy, not speed. I repeat, my lords, not speed. So the Kenya's National Assembly Standing Order 64 runs opposite to this democratic pattern. Article 124 creates standing orders as subordinate procedural instruments. Being subordinate procedural instruments, they therefore cannot dilute Article 10 on participation of the people as a national value and principle of governance. They cannot dilute Article 118 on public access and participation. They cannot dilute Article 1 on sovereignty of the people. They cannot dilute Article 47 on fairness in administrative actions and quasi-judicial outcomes and decision. My Lord, they cannot dilute Article 50 on fair hearing and Article 2 on the supremacy of the Constitution. As I conclude, my Lord, constitutional obligations are not optional where timelines are tight. If timelines make it impossible, then those timelines must yield, not the Constitution to yield. My lords and my lady, would want you to look at expediting the process as a value, but participation of the people should be looked at as a constitutional command. When they conflict, then the Constitution prevails. We respectfully invite this Honorable Court to hold that the National Assembly Standing Order 64-2, and to the extent inconsistent Standing Order 64-6, why we say so, my lady and my lords, is because the 2-day timelines is provided in the Constitution. That is what has been captured under Standing Order 64-6. Violate Articles 10, 118, 1, 2, and 124. If you find favor with our prayer, then Standing Order 64, 2 and 6 should then be found to be invalid for being unconstitutional. My lady and my lords, as you retire to write your judgment, we need to answer to this question. We kindly request that you address yourselves to: can sovereign will expressed through election be reversed through a process too hurried, like that at the National Assembly, having been given 7 days for the people to meaningfully participate in it? We look forward to a respectful answer of no. And for these reasons, we respectfully urge this Honorable Court to declare the Standing Order 64-2 and 64-6 as unconstitutional, null and void, to the extent they impose timelines whose purpose and effect is to undermine the articles that are mentioned, 10, 118, 1, 2, and 124 of the Constitution. I so respectfully submit. Thank you.
Thank you.
My Lord and my lady, my name is Njomo John. appearing for the first petitioner with my colleagues, and I'll pick up from where my learned colleague Faith Waigo has left. I rise to briefly submit on the reliefs that the first petitioner is seeking before you. I know council who has submitted before me have mentioned variously part of what I'm submitting on, and that is the reason why I will not take long. My Lord, when this court delivered its ruling on the 31st of October last year, I want to refer to paragraph 158, being the background under which the first petitioner is before you. He's literally in court today. Your Honor, there were worries as to what the court would do in the outcome of an impeachment and election or nomination of a deputy president in replacement of the second deputy president. And this is what the court said. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience. Moreover, the Honorable Attorney General, through Senior Counsel Githu Muigai, has given an undertaking to comply fully with any orders that this court, any orders issued by this court in this matter. So that when we come before you, this court has an open page. All the reliefs that the petitioner is seeking are grantable by the court, because even Professor Githu Muigai, it's on record that he has given an undertaking that there will be full compliance. So that, my Lord, the reliefs that the first petitioner is seeking are captured at paragraph 148 all through to paragraph 148 of the submissions. This is appearing at page 61 of the submissions by the first petitioner. Page 61. That is prayer number H. What are the appropriate reliefs? Starting from paragraph 148, running all the way to paragraph 152. And Your Honor, there has been various mentions of the issue of public participation. I want to address the prayer relief number 1, that is A, a declaration that the respondents have contravened the provisions of Article 10 and Article 118(1) of the Constitution by initiating a process leading to the removal of office by impeachment against the petitioner. My Lord, relevant to that particular prayer is the definition of what Parliament is at Article 93 of the Constitution. And this is what it says. There is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. And very briefly, my Lord, we have been told there was some semblance of public participation conducted by the National Assembly. But on record, nothing has been demonstrated, or rather, the respondents, especially the Senate, has not given any indication that there was any semblance of public participation. The reason why I'm saying this is because Parliament is both the National Assembly and the Senate. Even if there was some public participation initiated by the National Assembly, there was none whatsoever that was initiated by the Senate. This is the reason why we are saying that there is violation of Article 118(1) of the Constitution, because the Constitution requires that Parliament shall conduct business in an open manner, and in its sitting and those of its committees shall be open to the public. It goes further to say that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So that then the question is, what happens when the Senate conducts its business without involving public participation, without invoking public participation? The answer can only be that there is a clear violation of Article 118, 1 of the Constitution, and we pray that then the court finds that in favor of the petitioner. My lords and my lady, we have gone to pray for a declaration under B. I don't have to read the whole of it, but it has been explained by counsel that some of the charges that were confirmed against the first petitioner, there was multiplicity and duplicity of charges. That you have allegations and the particulars being referred to in support of a given allegation. So that then what we pray under a declaration that you are seeking under B, motion lacks the particularization and specificity required by Article 145(1) of the Constitution. This is important because it was submitted by Senior Counsel Ongoya, and he explained in detail how the charges 3, 4, and 5, particulars that were relied upon were in particulars or the charges in A and B, charge 1 and B, so that there were no particulars in support of those other allegations. The next prayer that the petitioner is seeking is as regards the inconsistent and violation of the Constitution under B, a declaration that the resolution passed on the 8th of October 2024 by the National Assembly to impeach the petitioner pursuant to the provisions of Article 145 and 150, and the communication dated 8th October 2024 sent by the Clerk of the National Assembly to the Senate titled that are both founded on a process that is inconsistent and in violation of the Constitution of Kenya. The reason why this prayer is being sought, my lords and my lady, is for the reason that there were many inadequacies resulting to the impeachment process, both at the National Assembly and the Senate. So that the culmination of it is that the process was a sham, and whatever that resulted from that particular process cannot sustain the impeachment process. So that we pray that the court can grant prayer number C as sought in the amended petition. My Lord, we also sought a declaration that for the purpose of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. My lords, the background on this is that the election of the Deputy President and the President takes place at the polling station. Counsel who has submitted before me have explained to my lords that the initial notice that was given was that public participation was to be undertaken at the county level. Subsequent communication was that there will be public participation at the constituency level, without an indication as to where the venue and more details to allow members of the public to meaningfully participate in public participation so that they can give their views. So that without a clear communication that public participation was to take place in all the 290 electoral constituencies and the 1,450 electoral wards, then that process cannot be said to have met the constitutional threshold on meaningful public participation. It is for that reason then that, my lords, we pray that you can find in favor of the first petitioner the declaration that is seeking under D. The subsequent declaration is on the timeline that was given, a declaration that the 12-week period provided under standing order 64.2 and 64.6 of the standing orders of the National Assembly is grossly insufficient. My lords, I will not repeat that because Counsel Faith Waigua has elaborated on the inadequacies and the prayer to have the same declared unconstitutional. Subsequent to that, my lord, we have prayer number F. Most of those others I'll consolidate. A declaration that the proceeding before the whole House plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited to time-bound 10 days. This is, my lord, what Ochiel Dudley explained that the 10 days that the Senate imposed on itself was not, did not have any legal basis, so that it was not justifiable for the Senate to impose itself on a 10-day period to conclude the business in a very rushed manner. As it was indicated by the Speaker of the Senate, they wanted to do that with military precision so that they could attain a premeditated outcome in our submission. My Lord, prayer number G is a declaration that the petitioner's right for fair administrative action under Article 47, a right to fair hearing under Article 50 of the Constitution were violated. My Lord, it has been explained in detail how the first petitioner was denied a fair hearing, so that even at a point when he fell ill, it was communicated to the Senate, and Senior Counsel Paul Muite explained to the Senate the circumstances under which he was not able to proceed with the hearing before the Senate. The Senate proceeded, regardless of that particular communication, to proceed with the impeachment process. So that is a very clear indication that the process was not fair, and the rights of His Excellency Rigathi Gachagua under Article 50 were violated to the fullest. My Lord, declaration number H that you're seeking is that the National Assembly and the Senate, in their evaluation of the impeachment proceeding before them, failed to properly assess each of the specified ground and determine if they collectively and individually constituted gross violation of the Constitution. My Lord, it has been explained to you again that even where a provision of the law has been declared unconstitutional, the National Assembly and the Senate still proceeded to find and uphold those particular allegations. The alikees have been explained, and the court has been taken through the process leading to the invalidation and declaration of the unconstitutional provision under that particular act. But nevertheless, the National Assembly did not consider it necessary to find that some of those allegations were even illegal, were unfounded, and could not stand the test of law. Next to that is an order that this court quashes several documents and communication. I will not read each and every order, but we have sought orders of certiorari to remove and quash the communication of 8th of October 2024, 17th of October 2024, resolving to remove the office from office by impeachment His Excellency Rigathi Gachagua as the Deputy President of the Republic of Kenya. The reason for this, my Lord, is, as explained before, that there were legal illegalities that were committed along the way, and these particular notices of 8th of October and 17th of October were the culmination of those particular illegal proceedings, so that the only justifiable cause that the court can give is to quash the notices of 8th of October and 17th of October 2024, respectively. Subsequent to that, there is also a request or a prayer that the notice by the Senate of 17th of October be quashed. This is the notice communicating the impeachment of His Excellency Rigathi Gachagua to the National Assembly. My Lord, we have then all the other prayers that we have sought. And my Lord, by the time someone is being elected to the office of the Deputy President or any other office, the expectations that come with it. We have given an authority that this court can award damages where there are violations of the Constitution. This is the case of Imanyara versus Republic, where the court held that where there are violations of the Constitution, and this is at paragraph 151 of our submissions. My Lord, you'll have a chance to look at it. The case of Imanyara and two others versus the AG, 2016 E-Kenya law reports, that where the court said that award of damages for constitutional violations of an individual's right by state or government are reliefs under public law remedies within the discretion of the court. So that at paragraph O of our prayers, the first petitioner has come before you and is praying for general damages, punitive and aggravated damages. These are not far-fetched because the court has previously found that they are awardable by the court, because if we have demonstrated to the court that his rights were violated, then the court can award damages as prayed under paragraph 01 of our submissions. My Lord, we have also explained in detail that he was earning a salary that maybe I don't have to give a figure because there's a lot of calculations, mathematical calculations, but you will have a look at paragraph O, where we have listed the benefits that the Deputy President was earning, what he was entitled to, and what his salary could have been if he worked for the 5 years that the Kenyan people had given him a mandate. So that we have therefore calculated those particular salary expectations and benefits that he was entitled to under the law. And we pray that the court can allow and award those particular prayers as sought. My Lord, the office of the Deputy President attracts some benefits, again, other than the salaries, which we have enumerated under paragraph P, because there are quite a number, including quite a number of issues, cleaners, gardeners, and all that. I believe that my lords will have a chance to look at those particular prayers and the allowances that he could have been entitled to, could he have served his full 5-year term. We do have the play that the court will allow the prayers as sought, and I believe you'll have a chance to have a look at all of them in detail, one by one, in awarding and agreeing to allow the petition as prayed. I think, Mr. Mashari, you have a word to mention about it.
I just wanted to remind my colleague that he needed to emphasize that most fundamental matter called costs. We need costs on behalf of the Deputy President for all these bad things that have been done to him and to us. Thank you very much, my lords.
Well, that concludes the highlighting on behalf of the first petitioner. We thank you.
Thank you. I see Dr. Gada standing up.
Yes, Your Lordship.
You said you wanted 2 hours, huh?
No, 2 hours. We will be done in an hour less. Myself and my brother Sakim.
Hello?
We'll come